Testimony continues in the sleepover kidnapping murder trial in Iowa. Henry Dinkins is accused of the 2020 murder of 10-year-old Bresia-Terrell. She was last seen at his apartment for a sleepover with her half-brother, who is the defendant's biological son. A forensic anthropologist took the stand today and testified about finding Briesia's remains and the evidence collected at the scene.
As the brush started to be removed, describe what was being discovered.
So again, the remains were mainly in this main concentration in the area where they were first found, around that area where the skull was found. During the hands and knee search, we just found little elements. We found some fingernails, some hand or foot bones slightly away from that concentration.
All right. And then were there any areas where there was a section of the body that had been drug away from the main concentration?
Yes, so the left lower limb had been drugged west of the main concentration.
Okay. As you were looking at those skeletal remains, was there anything that was particularly obvious to you?
At first glance, I could tell that they were the remains of a subadult or juvenile. When you're a child, the ends of your bones aren't actually fused on. That's what allows you to grow taller until you reach skeletal maturity. And so those ends are called epiphyses, and I could see at the scene that we had these epiphyses there.
All right. Was there any hair associated with those skeletal remains?
There was a hair mass at the scene.
Describe the hair mass.
It's somewhat outside the scope of forensic anthropology. I mean, it had shell beads in it. It was a dark brown or black color, but I'm not a hair expert.
No, and that's exactly what I needed. I just needed to have you describe the physical appearance. So then at that point, then, did you start the process of collecting those bones?
So once we did our hands and knee search and removed all the debris around there, making sure that we had found all the elements, they were again documented so that we had that third documentation there. Once DCI agreed that they had all the documentation they needed in that case, we did begin to collect those elements and place them into body bags.
When you had removed what would have been the obvious skeletal remains, is there anything else that was done just to sift through the dirt to see if you could find anything else that was associated with that body?
Yes, it's common procedure once all the elements that are on the surface there are recovered to take a trowel and scrape the soil. Sometimes over periods of time, elements can kind of sink into the soil. So I did that about 1 centimeter deep in that area of the remains.
As a result of that process, did you make any further discoveries?
Yes, I found a few additional teeth and then 2 artifacts that were later determined to be bullets.
Okay. Relative to the hair, did you examine the hair up close to see if there were any artifacts in the hair out there at the scene other than the shells that were very obvious?
I did not.
All right. But at any rate, was that mass of hair then collected and placed in the body bag?
Yes, typically we try to collect everything, disturbing as little as possible, so that the forensic pathologist then has whatever the remains were associated with in context.
Okay. Was there any clothing associated with those skeletal remains?
There was some clothing.
Do you recall what those articles of clothing were that was associated with the remains?
I think I recall an undergarment that was in the area. I heard of maybe other clothing in other parts, but I wasn't involved in that.
Okay. And then was there clothing attached to the skeletal remains when you came across it, or right there in the central concentration?
So I recall, like I said, some kind of undergarment that was mixed into the remains, and there was a sandal or a shoe that was nearby.
When you were making an age determination, what age did you identify for these remains?
If these remains were female, it was between 9 and 12 years of age.
9 and 12 years of age. And then in your examination of the skeletal remains, did you note any trauma?
I did.
Describe the trauma that you noted.
There was a semicircular defect to the inferior portion of the left mandible, which was consistent with a bullet impact traveling left to right through that mandible portion.
Okay. Based on the point of entry through that mandible, were you able to determine a trajectory or a path of travel for that bullet and where it would have stopped?
Yes. So based on the outside, the semicircular defect there. The inside of the mandible bone had internal beveling, so the defect is larger. That indicates that's where the bullet was exiting that bone. So I could tell the entrance versus exit through that one portion of the mandible, suggesting left to right. And then I also had a defect, kind of a circular crushing defect between the third and fourth vertebrae in the neck, the cervical vertebrae, that would be consistent with a bullet impact. And in this case, I was able to anatomically align them and show that they could be from the same trajectory, from the same bullet.
All right, still with me, criminal defense attorneys Josh Tellini and Brian Gaither. And Brian, I'll start with you. You know, Earl Dinkins was in the very beginning of jury selection when they decided to go with a bench trial. And normally when you go with a bench trial, you may decide to go in that direction because you want to argue a fine point of law that you think a judge might understand better, or it reminds me why they might have chosen in this case, because I don't think that other one exists. It's that, you know, you're hearing about a child being killed with a gunshot wound. You hear about the little hair that she was able to identify. You see the beautiful pictures of this little girl. The only chance this guy may have is to keep emotion out of it. And, you know, if you had a jury, that would be a big problem for him.
Well, I think I agree with you completely, because it paints a horrific picture to a jury. But you have to realize that judges are human too. So I think that's, you know, you can't just throw out the whole jury trial thinking the judge will give you a better outcome, trying to take out emotion, because that judge is a human. And now it's the judge, it's just him or her, rather than 6 or 12. So yes, I do agree that this was a strategic way to potentially not put this in front of a jury that can potentially not like these facts just off of hearing it. But judges are just as human as the jury, and now you only have one shot.
Yeah, that's an interesting point. Just, I want to get your thoughts on this as well, because, yeah, it's right. The judge is just as human. But if you're arguing to 6 or 12, you know, that increases your chances of catching one. Because one thing in the favor, I'm not saying this is a big thing, but one thing in favor of the defense is that there really is a lack of physical evidence connecting the defendant to this crime and to the crime scene. Some coincidences that have to be explained, but none of the physical or forensics seem to support the fact that he killed her. Your thoughts?
Well, I mean, it seems to be pretty strong circumstantial. I mean, she went over there for a sleepover, and then he says she's just not there the next morning. She's found, you know, 20 miles away, like that. So I think it's circumstantially, it seems pretty problematic, you know, for the defense. In my experience, it's generally never a good idea to waive a jury and to try to go forward just with a judge. Because I agree, the judges are people too. They have the same, you know, emotions. And not only that, they may worry about an election or being retained coming up in the future. And if they're the ones that were to acquit him, then that's all going to be on them, and everyone's going to look at him like that. Whereas there is something where you have 12 members of the jury, one person can just hold out and say, they didn't prove it to me beyond a reasonable doubt. And that person is kind of left in anonymity. And so it gives you a little bit better shot, especially on a horrible case like this.
Yeah, and you know, again, the only time it really makes sense to me, gentlemen, is when there is a fine point of law that you want to argue, that you think might be a little bit more difficult to sell to a jury, that may be easier to sell to a judge. But I agree with both of you. Very, very few situations that I think it's better to go with the judge than the jury. Here's the other thing that I see about this case. The defense attorney sort of works well with this. His girlfriend is the only one that puts the girl by his car. He claims, or his statement to police was, he got up at 3 a.m., had to go out, he went out. When he left, everybody was safe. Now, Andrea, who is his girlfriend, his live-in girlfriend at the time, basically all she says is that she looked out the window and saw her by the car, but she didn't come forward with that information till 4 days after. Brian, that's something to work with, I think.
Oh, of course it's something to work with, because, you know, the time period, you can always make an argument, why did you come 4 days afterwards? But like I said, at the end of the day, it's still, what's coming out is still what's coming out. So like I said, that's an argument. and we have to just see how it falls.
Yeah. I mean, I'm throwing it out there because this defense is clearly reaching for straws at any guess because the evidence is really stacking up against this guy. All right, gentlemen, thanks to Josh Tolini, Brian Gaither for joining us today. Really appreciated your insights, gentlemen. Thank you so much. We'll see you again soon. Folks, coming up next, we're going to review the 3 things we've learned today and the cases we've been covering from coast to coast right here on Court TV.